second accused made any alleged misrepresentations. And he said the test for proof beyond reasonable doubt is settled. He said if emphasis must be placed on that, if an explanation given by the accused person, or if they are given by the second accused person, cannot be said to be false beyond reasonable doubt, then there is no proof beyond reasonable doubt. He said the second accused person's defense was fully supported by his unshaken evidence. He cited S versus Kuipa, which I must read. Said the test to be applied before the court rejects the explanation given by the accused was set out in a South African case which is cited therein, and that is the Default case, celebrated Default case of 1937. No onus rests on the accused person to convince the court of the truth of his explanation. If he gives an explanation, even if that explanation is improbable, the court is not entitled to convict unless it is satisfied. Not only that the explanation is probable, but beyond reasonable doubt, it is false. If there is any reasonable possibility of his explanation being true, then he is entitled to his acquittal. They also cited the Makanyanga case, which says that the failure by the accused to win the faith of the bench does not disqualify him from acquittal. And then the other cases there, which have been cited by all the parties here, and regarding sufficiency of evidence or what constitutes proof beyond reasonable doubt. Importantly, which does not relate to, and they said the application of the law to this case is that from the above law, the state's attempt to rely on circumstantial evidence cannot even begin, because there's no proved facts that qualify as facts under the two cardinal rules in Ara versus Bloom. By the close of the trial, those were the submissions, the state had not brought the second accused person into the trial. Counsel criticized the state for attempting to link the accused person through the following four circumstances, which are listed as that he approached Alban Minduwa while in the company of the first accused person for advice and how to proceed. That, I should have said, that he allegedly approached him, that he allegedly participated in meetings, that he, on the 7th of February 2023, he attended, that of course is common cause, a meeting at the Ministry of Lands to find a way forward in respect of the progress of Nena, and that he attended the launches for the scheme. Those are the four circumstances which, according to the first, second accused person, the state sought to rely on. The counsel said, even without going into the truthfulness and otherwise of the alleged offense, firstly, the four circumstances relate to alleged events after the award of the tender. That was after the commission of the offense. The offense of fraud is committed at the point that the misrepresentation is made and the subsequent inducement of the victim to act to his prejudice. The offense would have been committed at the time that the tender was awarded, and all these other circumstances arose after. So, those circumstances, even if proven, did not link the accused person, the second accused person, to the crime. Secondly, and in any event, the second accused person gave a completely convincing response to each of the alleged circumstances as follows. He never went with Alban Mindurwa in the company of went to see Alban Mindurwa in the, I must take that again. He never met Alban Mindurwa in the company of the first accused. He said he challenged Mindurwa's evidence in cross-examination. He held that position through his own. In chief, he said his version was not seriously challenged under cross-examination. He said Mindurwa did not produce any meetings, any minutes of the various meetings that he alleged he held with the second accused. He said it was not true that he participated in negotiations in respect of Black Dick's performance. He said the evidence of Obed Jiri was speculative. In fact, Obed Jiri did not persist and with his evidence, what he had said regarding the second accused person when he was under cross-examination. I will repeat that. In fact, Obed Jiri did not persist with what he has said against the accused person in his evidence chief when questions were put to him under cross-examination. He admitted attending only one meeting where he appeared in his capacity as the member of EEG and as a personal friend of the first accused. He wasn't representing Black Dick. He attended the lounges as a politician. He said the circumstances were therefore either not true or adequately explained. He said the state attempted to link him through what it called association. There was absolutely no basis for the doctrine of association, as no legal authority is cited for its invocation. He said his company, Militech, submitted a bid. It was a competitor of Black Dick Private Limited. It would be wild to suggest that the second accused person would then participate in the tender process by Black Dick. The second accused was subcontracted by he said his company, Militech, was later subcontracted by the winning bidder. So there was no evidence to link him with the alleged misrepresentation, that is the documentary exhibits which were alleged to be false. In conclusion, counsel submitted that on behalf of the second accused person that the second accused person's defense was clear and unambiguous. He just did not make any misrepresentation or the alleged misrepresentation. He never submitted any documents, so there was no link between him and the tender documents. He prayed for his we were required then to, on the basis of the evidence and the submissions made to us, to consider whether the state had established his case beyond reasonable doubt. I've already alluded to what the state had to prove and the issues that arose from the pleadings, the state outline and the defense. We have already identified that. We will therefore deal with the identity of the bidder and its registration status in terms of the laws of Zimbabwe that govern registration of companies. The bid document was produced as Exhibit 40. Conspicuous on the face of the bid was the name Black Deck Livestock and Poultry Farm, which was in capital letters and written in bold, as I have said, and with mixed black and red. At the top left corner is a small logo written Black Deck Private Limited. The address which appears on the face of the bid is 8 Carson Close, Grindel. The first document in the bid is a letter signed by T. Dembo addressed to the procurement